Well, good morning, everybody. Thank you for your participation. My name is Scott Clements, and I represent the Community Associations Institute Orange County chapter. CAI is a not-for-profit mutual benefit corporation dedicated to the betterment of community association living. Founded in 1973, currently we have 40,000 members in 60 chapters worldwide. CAI membership is comprised of individual homeowners, or homeowners associations, HOAs as they're called, board members who govern them, and service providers who offer them, such as legal and financial services, and of course, management, financial regulation, and contracting work. There are 9 chapters in California. We represent the largest in Orange County. Our goal today is to educate the realtor population on the myriad of issues that come up when dealing with a HOA transaction. As you know, there are a lot of laws specific that govern them, and we're going to cover most of those today. The crown jewel of the CAI program is our Community Leadership Training Program. It's a multi-part series on law, finance, insurance, maintenance, and so forth. And it is 12 to 14 hours long over several days. So that was the challenge that we had. So what we've done today is we've condensed our Community Leadership Training Program into what every realtor would need to know. So if you are a community leader, or if you own or operate an HOA, then we would recommend that you go to the full CLTP program. We've narrowed this down just to talk about the things that every realtor needs to know. So with that, there are a couple of documents that you were given. You're given a copy of this PowerPoint. We're going to roll along with that. Also, you were given a copy of the Davis-Sterling Act. We were able to get that secured by a law firm. It is the body of law that governs HOAs. So it's a good resource for whenever you're going in. I know that most of you are tuning in today to say, where are the documents that I can get in the middle of the transaction? Where does it say we can get that? Well, we're going to cover that today. Okay, Easton Strasburger, we're not going to spend a lot of time on this because I'm sure your brokers have dragged it into your head quite a bit. What I like to point out with Easton Strasburger is that they weren't alleging that the real estate agents in this area were corrupt. They were including that they were negligent in the fact that they were lazy. All right, so you don't have to prove corrupt or malfeasance in this process. It's just laziness that they got. So as we take that one step further, the Easton Strasburger, of course, made the adjustments to the civil code as it relates to your duty as a real estate professional. And of course, they're referring to the physical elements of the property. When you're talking about an HOA, of course, you're not going to get access to most of the common areas. So the question is, what should you provide in the way of information or consultation as it relates to HOA information? So in the next couple of hours, we're going to talk about how it's important to make an effort that your clients have copies of all the important HOA documents, CC&Rs, policies, use of enforcement, and we're going to tell you how to get those. Now, of course, it's not your responsibility to try and interpret those. We're going to give you expertise on how to do that. And hint, it's cai.org, because there's a number of attorneys there that can interpret that. So it's not your role to interpret those documents. It's to make sure that your clients get a hold of them and find that expertise elsewhere. Also, it's important to make sure your clients are aware of any of the use restrictions. So we're going to talk about the policies and procedures and the other things that are given to the membership and that you would want to give to a prospective member on what they can and can't do. Short-term rentals, pets, etc. Very important for somebody who's making a living decision. And then you want to make sure that your members have up-to-date financial information, that they understand what a reserve study is, how to utilize it, the financial operations of the HOA, and make sure that they're financially solvent. And then last but not least is make sure that they're protected with insurance. Of course, HOAs are required by law to have insurance. We're going to talk about that. But homeowners themselves are going to have some individual exposures. So they're probably going to be required to have some level of insurance by their lender, and certainly just good risk management practices. So you want to make sure that your clients are talking to an expert in HOA policies so that they can give them the right advice. So with that, we're going to get into the law section. I'm going to cover the law section, and this is not legal advice. It is not legal advice for 2 good reasons. Number one is this is a public forum. To be legal advice, it would have to be given in private because you would breach the attorney-client privilege. But the main reason this is not legal advice is because I am not an attorney. All right, well, there are a lot of here is a condominium. There are multiple types of common interest developments, HOAs, as we've talked about. And there's a legal term, it's a condominium, and that's a term of ownership. So in a condominium, the ownership is the building, right, of the units, and the HOA owns the building and most of all of its operational equipment. The individual owns the airspace in between, not the drywall. No, that's part of the building, just like the studs behind that and so forth. So they own the airspace in. So if they painted that, that's their paint. If they put drywall, if they put paneling over that, if they put wallpaper, that's all theirs, but they own that airspace in. Similar as it relates to the major systems. So the plumbing lines that run between the walls, that's going to be the responsibility of the individual, of the HOA. Once it gets to the unit, that angle stop underneath the sink, that's generally when the responsibility takes over. So a common area is pretty much everything. The unit is the airspace within inside that specific unit. A planned development, this is for single family dwellings as we're typically called, and that's where somebody owns a lot. So instead of the airspace inside of a unit in a multi-building, this is you own a lot and you can build according to whatever the CC&R say on that lot. So this shows the term. So a planned development and a common area will be listed in all of your lot plans, all of your development, all your disclosures as to where each of these lots take place, and of course where any common areas such as where the rec facility, pools, etc. would be. There's a couple others that are out there. They're not as common, but they are still operational. We have some in Long Beach. I think Karen could probably speak more to some others. I don't know if Laguna Woods or Seal Beach are still operating as cooperatives or community apartment projects, but they operate much like a condominium in that the individual owner has the right to occupy the unit and the association is responsible for the repair, maintenance, and so forth of most of the major components. Townhouse. Townhouse is not a legal term. It's not a type of ownership. So it's often used as a marketing. It's also a construction term. So you've heard the term single family dwelling. You've probably heard the term townhouse, condominium, high rise, apartment style. So those are all construction terms. From a legal standpoint, those don't mean anything in the HOA world. So a townhouse can be a PUD or it can be a condominium. A single family home that's not attached to anything can be a PUD. It can also be a condominium. So that's why it's so important to understand your governing documents to be sure of what type of an association you're in. Talk about the laws that cover them. The Davis-Stirling Act was enacted in 1986. It has been amended a mere 130 times. Yes, that's not it. It's 130 times. So that's a few times every year. It is about 150 pages printed out on space type. I'm a big promoter of this wonderful book here, as you'll see in a second, the Condominium Blue Book. So if you get it in this condensed format, it is only 232 pages. The other good thing about the Davis-Stirling Act, it is a cure for insomnia. So anybody who suffers from that, please feel free to use that. Okay, so the sources, we talk about the Condominium Blue Book, and the reason that I like this, and maybe not for every individual real estate person, but certainly if you are involved in HOA management or so forth, and maybe for a broker or have a large audience, it's a great resource. It has all of the stuff that we're going to be talking about. So it has the Civil Code, the Davis-Stirling Act. It also has the full Corporations Code, and also has case law and other information that is valuable for anybody who's actively involved or wants to look something up. So we talk about the hierarchy of documents and so forth. Well, all HOAs, regardless of their situation, regardless of their PUD, stock cooperative, et cetera, still have other laws that they have to obey. Now, most corporations, most HOAs are set up as corporations, and most of those are set up as mutual benefit nonprofit corporations. So there are sections of the Civil Code and the Corporations Code that will cover those regardless of how they operate and so forth. So for instance, most associations are going to be required to have a filing for taxes. Whether you pay taxes or not, you're still required to apply those taxes. So those are going to apply to everybody regardless of their legal ownership situation. The Vehicle Code, some of you may know from the unfortunate experience, others just may know, HOAs can tow your car. Well, pretty much as anybody on private property can tow your car. However, they must comply with the Vehicle Code in order to do that. One of the most obvious is they have to have a sign, right? If there's no sign, you can park there. Public parking doesn't have a sign. So private parking that is prohibited must have a sign. So as long as the HOA has followed the procedures in the Civil Code, they can use all their rights that are afforded to them under it. Health and Safety Code is also a requirement. And this is, of course, for all associations, but particularly for those that have amenities. So if they have a recreation area, a pool, spa, et cetera, there are a lot of codes that go into the process of this. They also would have to follow the areas as it relates to hazardous materials. So HOAs can't have lead, asbestos, or other of these materials that are just simply not allowed under the California Health and Safety Code. You probably remember this a few years ago when you saw all those defibrillators showing up in your gym. Yeah, it's because California passed the law that all these athletic facilities have to have them. So again, HOAs also had to comply. So not only did you see them at your local LA Fitness in your high school, you also saw them in your HOA. More federal stuff. Okay, so the Americans with Disabilities Act is for private property. However, it is not for HOAs, with the exception. So if it is a open property, commercial property, etc., public access, it is deemed to be within the ADA. HOAs are private, just like your individual home. So if that's the scenario, HOAs do not have to comply with the Americans with Disability Act. So your elevators don't have to comply, your bathrooms, et cetera, access, et cetera, do not require comply. However, with that said, there can be some exceptions to that. So let's say hypothetically, you have a really large rec center with a great pool. And once a year, you invite several high schools to come in for a big swim meet. Well, that day you're open to the general public, so you would have to comply with the Americans with Disabilities Act on that day. So again, if you have to modify some things, well, you might be compliant every day, but for that day specifically, you're going to have to be compliant because just for that one day or that period of time, you are in fact open to the public. The Fair Housing Amendments Act, and that is to the what they call the 7 protected classes, and you see them down there: abilities, race, sex, color, national origin, religion, or family status. So HOAs can't discriminate against people based on those circumstances. Now, we'll talk about it in a second, but they can have parts of their bylaws and so forth that can do it. So for instance, if they want to have something that says, oh, hypothetically, at least one person on the title must be 55 years of age, that is not considered an unreasonable restriction because you're saying, hey, I'm not saying kids can't live there. I'm just saying one of those people has to be an old adult. I shouldn't say old, I'm old, 55, a young adult. The bankruptcy code also applies to HOAs and to everybody under the sun in federal world. So you have to follow those procedures. And this is particularly important as it relates to the Fair Debt Practices Act, because this has certain requirements and limitations on what you can do. So again, a hypothetical situation, if somebody is behind on their assessments and you pass them in the hallway every day and you keep reminding them that, right, that could be considered harassment under the Fair Debt Collection Practices Act. So the recommendation from me and all the other attorneys that are real attorneys will tell you, have that done by a professional, because it just creates so much liability for the individual association. So I know in small associations, it can be a hassle, but most large law firms in this industry have a lien collection or a collection agency that's fairly reasonable, and they don't take a big chunk of the money. It's a fee service. So I would recommend that HOAs use that versus getting yourself into trouble, because the Fair Debt Practices Act is quite lengthy and quite detailed. Case law. Well, remember at the start of the program, we talked about Easton versus Strasburger, which is your guys' case law, right? Well, we have case law too. Now, the situation with case law is a case that it's gone through the process. It's gone to the Appellate Division of California, and it's been approved or denied, and it has been published. And so what happens in these scenarios is that now future courts can look to see similar fact patterns so that they can make a decision. So this doesn't mean this is absolutely how it's going to have to go, but it helps give an idea as to where the thinking was on it. So again, after Easton versus Strasburger, and I probably should have started off with this. I'm a recovering realtor, and I got into the industry before Easton Strasburger. Yeah, that's how old I am. So, you know, a few of us are still out there combing the earth. So it was a much different environment before Easton Strasburger versus after Easton Strasburger. So after Easton Strasburger, we found what? Home inspections. We like those guys, right? The guy would come out and do the home inspection and take all that liability off you. And then we had these environmentals. Like, I don't know if that place was ever used as a dry cleaners, but somebody will come out and do a history on that. So you've got these property IDs and others. So the Easton Strasburger was a milestone in your industry and changed literally the way that it operates. Well, we have some of those cases too. We're not going to get into them specifically, but if you buy that wonderful book that I love and get no money from, the Condo Blue Book, it will talk about some of those specific issues. Then we get into what we call the governing documents. This is a generic term that people use for a series of documents. So it's not a singular document, it's always a series of documents, usually 3 or 4, but it's a group of documents. And I think the most important of that we would call is the CC&Rs. Covenants, conditions, and restrictions. Most of you are familiar with the CC&Rs. If you're not familiar with what CC&R means, I wrote it down because I had to look it up myself. Oops. Just lost my page. So the covenants are the warnings. This is what you can or can't do to the property. So if you want to raise chickens on your place, probably not going to be allowed in most homeowners associations. So the covenants are what you can and can't do. The conditions, well, the condition is that you maintain your property, that you pay assessments, etc. And then restrictions, the things that you absolutely cannot do. So the document is recorded by the developer, usually early on in the process. It's all required to be part of the disclosures, the DRE information before you can even offer a condominium for sale. Usually it's changed by a membership vote only. So this is kind of like the Constitution. I think most of us have gone to a civics class, so we understand that the Constitution is the higher authority. It's the big. So in this instance, it would usually require that, that you have it adjusted by the membership only. Different CC&Rs will have different requirements for that level. Contains restrictions, including the use ownership restrictions assessment. So we talked about that ownership. So again, we can't violate law and say, hey, we can't have people of this certain age or ethnicity or origin, etc. But we can have restrictions that say, hey, at least one of this persons has to be 55 and up because we want to attract an older, quieter community. The covenants we recorded are given the presumption of reasonableness. So what that means is that they've gone through a long process. They've been disclosed to all of the purchasers before they've made the investment decision. So it's very difficult to go back after the fact and say, hey, these CC&Rs are wrong, right? So it's a very high burden legally to go back and challenge the CC&Rs because they're given the presumption that, hey, it was all reasonable and you had the opportunity to look at this before you made your investment decision. Okay, keep looking, by the way. If you have questions, go ahead and put them into the Q&A section. When we are done with each section, we will run through them. And of course, at the end of the program, we have a Q&A section set aside. So we may not get to your questions right away, but we will get to all your questions before we leave today. So please feel free to jump in with those. And I do see that the links to get the Davis-Sterling Act is up. So you might want to take advantage of that. Excuse me. There we go. The condominium plan. This is also filed with the county, and this is the very specifics of the property. So it'll often show common area versus the unit. And as you can see, it's the detailed plan. So this is probably the most specific information in a graphic form that you're going to get. And then the final division subtract map is for, again, single families or that type where the individual owns a lot. So it shows the lot in the common areas, planned for the development. So it's a general lot area where the condominium. So sometimes these plot maps have condominiums and they're a group of sub-associations. It also is recorded prior to the construction of the product and often lists easements and rights. So for instance, let's say you've got 3 homes up in a corner and 3 homes share a driveway for a certain amount, say 30, 40, 50 feet. Well, somebody's going to own that lot, right? Because the HOA doesn't want to own that property. So that driveway is going to be on at least 1, maybe 2 or all 3 over a period of it. But somebody's going to have that lot area that there's a driveway on, and the other 2 have easements to go over at. And the reason that's important is, well, if 2 people have easements to go over your driveway, you can't modify your driveway to prevent that. They've got an easement in order to do that. So these kinds of important documents are available on site at the county recorder's office that you can review before you go to through the instruction process. You can also get them through the association, which we're going to talk about in just a second. So all these important documents readily available. Articles of incorporation. These are generally pretty simple, usually 1 page. They're filed with the Secretary of State and have to be refiled every 2 years to keep your name. As you can imagine, the creative names are all gone. That's why there's Boca del Vista Phase 4, Boca del Vista Phase 5, etc. But there is a legal name that these people will be, even if it is Boca del Vista Phase 6. Thank you for the Seinfeld fans for getting that reference. So it has to be renewed every 2 years in order to keep that. Otherwise, you lose your name in your filing. So it's very important to do so. But that said, that's all the information the state collects on associations. So we kind of know how many of them there are, and we know where their names are and how to get a hold of them, but we don't really keep more specific information than that. So the articles of incorporation will just tell you when the whole process started. They will often include things if it's part of the process, but they're usually fairly simple. The bylaws, these often get confused with the governing documents. So these are the quote laws that come from that constitutional document, the CC&Rs. So the documents govern how an association or an operation goes. So it includes information on the terms of the directors, whether they're staggered 2 years, 5 years, whatever it may be. Documentation inspection rights, which may or may not vary from the civil code. If that's the case, then the civil code is going to have precedence. often includes member discipline rights and voting rights and procedures. So cumulative voting, whether they allow certain responses, often includes member discipline. And we're going to talk about a little bit about member discipline in the past, but often that's part of the bylaws and has to be very descriptive, because if it's not, then you'll have to default to the civil code. The bylaws are not required to be filed with a recorder, but they often are by most firms just because they're such an important document. Rules and regulations. And this is the important aspect. I know one of the concerns, complaints, whatever you want to label it, for people in the transaction process is the cost and availability of documents. And one of the reasons that it can be so costly and time consuming is that they have to be up to date. So you can see here, rules and regulations can change, and they can change just by the board of directors. So big structural changes, yeah, you have to go to the membership and get a vote. Smaller issues, rules and regulations, well, the board can make those decisions. So they just have to give notice, which is a 28-day section to say, hey, we're talking about changing this rule. So we're going to limit the tennis court hours to 1 hour a day. Okay, well, that doesn't sound very practical, but it's within their right to do so. So as long as they give the 28-day notice and say, hey, we're going to do this. And then after they've done it, they've notified everybody, said, oh, yeah, tennis court's only allowed 1 hour a day, then that rule applies. So they can change frequently, particularly in some associations. So it's important to get the most updated copy. The other aspect is the civil code can regulate HOAs. The civil code does not regulate practitioners of community management. So yes, they can dictate what a HOA can do as it relates to fees, but they can't dictate that as a management company. Also, the HOA has some protections. It's just, of course, providing information it has at its availability, where the individual management company would take on additional liability if they're providing these documents. So that's why you're traditionally going to pay, in some cases, several $100s, even over $1,000 for a full set of documents in an escrow. And that's to be sure you're getting all of the documents that we're talking about now and we'll continue to talk about, and that they have been reviewed to be updated and current. Enforcement, everybody's favorite process. So the board should adopt a set of procedures and guidelines regarding the enforcement rules and regulations. If they don't have these, then they would have to default to the civil code. So among these procedures are violation letters to the board. And as you would imagine, these violation letters can cause a response. So you want to make sure that all of your rules and regulations are well thought out and have been reviewed by legal counsel to make sure that they're constitutional by conforming to the CC&Rs and other documents. And then once somebody violates these policies and procedures and the rules, then you have the opportunity to enforce them. Now, before you can enforce a fine or levy a fine, you have to give them the opportunity for a hearing. So it's much like, got to have your day in court. So you can certainly levy fines, but you have to give them the opportunity for a hearing. There's a whole section on that in the civil code. But if they decline that opportunity, then you can levy the fine. Once you've given them the opportunity to be heard, then you can still levy the fine, but you have to provide them an opportunity for their day in court before you can levy fines. Two types of dispute resolution. There's ADR and IDR. So right now we'll talk about IDR. That's informal dispute resolution, and that's a voluntary process. So the association must provide a fair and reasonable and expeditious procedure for resolving disputes arising from the Davis-Sterling Act or other codes. And they must also accept informal dispute resolution if asked. So if there's in a dispute and the homeowner says, hey, I want to go to informal dispute resolution, the HOA doesn't have a choice. They have to honor that request. However, on the other side, if the association says, hey, let's try and resolve this in informal dispute resolution, the individual can say, no, I have my rights. I want a court of law, et cetera, but no. So the individual homeowner has the right to say no. The HOA doesn't as it relates to the informal dispute resolution. Now we talk about ADR, the alternative dispute resolution. This is typically known as mediation and arbitration, which can be binding or non-binding. So mediation is just really a professional to help you negotiate a settlement conference, right? So they hear each side and they take into account, and that mediator is supposed to offer a kind of a buffer zone in between the two and explain where they might be should they take this to a court or a jury, often helping them resolve the issue. Typically never binding. Now, arbitration is what you would call a mini trial, right? So they go through, they present evidence, they have testimony, witnesses, expert witnesses, and at the end of it, they have a decision. So it can be binding or non-binding. So in a non-binding, it's It can be useful in that it will give you an idea where your evidence is. You think you got some really powerful evidence and boom, doesn't do that well, you still lose an arbitration. So it gives you kind of a mock trial ahead of time. It's also used, you've probably heard the term bleeding somebody from a legal perspective. So the more wealthier of the parties, and we're going to talk about that term in a second, but they can drag it out. So it's just like, well, hey, I'm gonna, have this done in 2 years. So, we'll go to arbitration. That'll take 1.5 years. Then we'll go to court. That'll take 3 years. Well, by then we'll be sold off the property and be done. So it can be a delay tactic as well. The binding arbitration is, as the name implies, it's binding. So you go through the whole process and it's just like a trial. So unless there's some real malfeasance in anybody's part in that process, another court's not going to overturn that. It's going to be deemed as binding. So again, risk and reward. So the good news is, yeah, once it's done, you're going to be done with it and it's over. The bad news is if you lose, there's no appeal. You're over with it and you have to move on. Lawsuits against homeowners. So this is the lawsuits against homeowners. We're not going to cover the lawsuits from homeowners against HOAs because I'm reminded of the Albert Einstein quote that the difference between genius and stupidity is that genius has limits. And so there's virtually no limit to the amount of lawsuits that can be filed on behalf of homeowners against their HOA. It's a wide range. So we're just going to focus on when an HOA can go after its homeowners. So they've got a few of them. One is a temporary restraining order. So again, hypothetically, they're going to build this nice gazebo in their front yard. They really love it and it costs a lot of money. And so they start the process. However, the CC&R say that, no, you can't have outbuildings in your front yard. And any changes to the property have to go through the architectural approval. So you've got two issues here. One, you're violating the architectural approval guidelines and it's not even allowed in the area it is. So you would go to court and say, hey, stop putting in that gazebo. And then you would go to court to get what you would know as preliminary or permanent injunctive relief to say, okay, now that gives the court the opportunity to hear the case, right? It provides opportunity to hear the facts and make a judgment. So they can say, all right, now that I've reviewed it and says, yes, it's clear the CC&Rs don't allow these types of structures in the front of the building. The CC&Rs clearly state that you have to go through this architectural process and may rule for it. On the other hand, what if they're not? Like, no, there's nothing in architecture to say they can't. And I don't see any specific language in the CC&Rs that say you can't put a structure in the front yard. So no, we're going to rule for the homeowner in this case. So that's why you have these processes. For damages. So the association can go say, hey, you caused damage. So while they were installing that piece of equipment, they damaged the street. The equipment damaged the street and we had to repair it. We had to, file attorney's fees and so forth. We're going to talk about that in a second. So we want to recoup our attorney's fees for the process of getting you to stop doing what you were not supposed to do. So there are damages that are borne by the association. They're welcome to go back and collect those. And then declaratory relief. So again, the court is giving you, a judge requires something like you never put in that gazebo in the front yard, or you pay them the money that you owe them, or you restore it to its original, what have you. But that's the declaratory relief that you're asking from a court to say, okay, Mr. Homeowner, you've had your day in court. This is exactly what has to do. So stop doing this or do that. Now, there are a lot of lawsuits as it relates to HOAs, but the real reason there aren't as many is the legal fees. It can be extraordinarily expensive. You can lose hundreds and hundreds of hours at thousands of dollars. So, most experts are several $100s an hour. A good attorney can be $1,000 an hour. So you get a bunch of room of these people together. You could be $5,000, $10,000 an hour for everything that goes on. A simple lawsuit can consume hundreds of hours. Complex one, literally tens of thousands of hours. So a small case going through court is usually a couple $100,000. So there's very few cases that ever get through any of the processes to a verdict that you haven't burned nearly $250,000. The more complex cases, you'll be out $1 million or more. So you can see there's a high motivation to settle these issues before they get to that process, just simply because the cost is so staggering. The other aspect that you have with these is that in most circumstances in HOA world, they have what they call prevailing party clauses. So at the end of the process, if you're not the prevailing party, you have to foot the legal bills for the prevailing party. Now, these were put in, of course, to protect the association because they get sued every time a barking dog annoyed a neighbor. So if you want to sue your association because they can't stop your neighbor's dog from barking, that's fine. But at the end of the day, if you can't prove it's your neighbor's, your HOA's one, responsibility and two, capability in order to stop that barking dog, you're not going to win that lawsuit. And not only are you going to have to pay your attorney's fees, you're going to have to pay their attorney's fees. So it's a dissuasion on both sides from frivolous litigation. So keep that in mind when you're thinking about going after your HOA, because they're using your money to go after you. So defenses. There are a number of these defenses to the lawsuits. I don't think we have to go into all of them because, quite frankly, many of them are limited. So latches, attachment. So, you know, this for that, kind of like, hey, you have to do this, but that's a waiver. You can ask them, hey, I know that's a rule, but I'm Vinnie Barbarino. Come on now, let's waive it for me. Make an exception, right? Estoppels, you're denying the facts. Okay, no, what they say is not true. So we're gonna go to court and hear about that. Change conditions. Well, you know what? The tree fell down. So the fact that I wasn't maintaining it, it's all over now because the dang tree fell down. That condition changed. So those are, you know, fairly common, but the most common that you'll see as it relates to the enforcement issues are number 5, selective inconsistent enforcement, right? So, oh, I got fined for leaving my trash cans out 72 hours past the timeline. Well, you know what? When the board president didn't, he didn't get fined. So now that's selective or inconsistent enforcement, and they can use that as a legal defense in why they shouldn't have to pay that fine. And quite frankly, that's a very common one because, you know, you can't catch everybody, and sometimes they're not trying hard to catch somebody, but they are trying hard to catch that one individual. Because, by the way, the civil code requires that each association have one crazy nuts member. It's in the back of the civil code, I'm sure somewhere. I have to look it up later. But so everybody's required to have the one nutty, you know, member in their HOA. And so, of course, they're the ones that everyone, you know, reads through the fine print on how can we penalize them for being a nutty kook. And we're going to go through the rule book and make sure we hit them every time that they do something wrong. And unfortunately, yeah, they do find these arcane rules that they can nab them with. But guess what? Other in the people community are breaking these arcane rules that nobody else follows. So you're going to get called on that. So that's probably the highest that I see. Discrimination. We talked earlier, you have the 7 protected classes. So they're going to make the claim that, hey, you're discriminating me because of my religion or because of my ethnicity or whatever. So that's a very common defense that they have, that you're only doing this to me because of X, Y, Z. Lack of notice or rules. And that's why, again, the civil code has all of these notices, postings, time before meetings, etc., so that you don't get caught into this process. So, you know, a rule is not a rule if it isn't published and known. Now, with that in mind, if it is published, then it's expected to be known. So if you have rules and regulations, and again, these are all required to be sent out annually. I think Karen's going to talk about that with the annual mailings, but there's documents that have to be sent out on an annual basis. One of them is your rules and regulations. So a member cannot go into court and say, well, I didn't know I couldn't park overnight. Well, you know what? You should have known because it's in the rules and regulations and it sent you. So ignorance for the law is no defense. So while if the association fails to have good rules or provide them to the membership, they can have an issue. As long as they're provided under the manner described in the civil code, they have an affirmative defense. Conflicts between governing documents. And this also happens. As I mentioned, the Davis-Sterling Act came into being in 1986. There are actually documents out there that predate that. I've seen CC&Rs that predate Davis-Sterling. So, of course, now a lot of these documents are moot because the Davis-Sterling Act takes precedent. And so often as these documents get updated, they will cut and paste from other areas. So it's not uncommon to see bylaws conflicting with CC&Rs or rules and regulations conflicting with the others. So if that's the circumstance that you've given out all these rules and regulations, like, hey, you know, you told me I couldn't, you know, park my apple truck here, but, you know, the CC&R say I can run an apple farm. So it's an unreasonable rule to say I can't have an apple truck if you say it's okay that I run an apple farm. So again, you have to make sure that all your documents are consistent with each other. Otherwise, you're opening up to offense that there are conflicts between all of your governing documents. Standard of care. We talked a little bit earlier about case law. This is one of the most cited case laws that you'll see in our industry. It's Behan versus Lido Isle. And this is what we created what we call the deference rule, or a good faith business judgment rule issue. Is that the fact pattern in the case wasn't that important, is the way that they were maintaining the property. And somebody sued, they didn't like that. And the court said, well, yeah, they went through the process. This is reasonable. It's just a way of choosing it. You know, there's one more way to skin a cat. So whether you fumigate a building, whether you local treat, whether you eradicate with, these types, those are issues that the board makes the decision. So they give them the deference standard. So unless that they have violated their faith, or were unethical in some matter, their decisions are their decisions. The court is not going to second guess or armchair quarterback the board and their decisions. So generally speaking, the rules that they make and the decisions they made are given deference as long as they follow proper procedure. All right, I know this is where you've been waiting for, right? The transfer of disclosure section. What can I get and how can I get them? Well, this entire section is in the Davis-Sterling Act, which is why we gave it to you. And again, thank you for the law firm for donating that. So whenever you're involved in that transaction process and you want to see some specific information, dig in, because it's long and it's hard. However, I'll just give you some brief information, and that is that the seller is responsible for this information. They are legally prohibited from collecting money. So they can't, hey, you want some information on this property? Who wants it most, right? No, if they have something in their possession, they're legally required to provide it to a prospective purchaser at no charge. So if they have it, they have to give it. Now, if they have to go get it from the association or the management company, it clearly states that the seller is going to be the responsible party. And that's because, of course, the other party involved, whether it be the management company, the HOA, they don't want to have to chase some prospective purchaser for the monies. So they make it, obviously you can work it into the escrow instructions or just write them a check or whatever. So it doesn't mean that the seller has to ultimately pay for these. It just means that the party they get it from is going to make them the responsible party, because they have no capabilities against the others. If the seller doesn't pay them, of course, they can lien their property, and that, of course, creates a title problem. And most people going to sell their property frown on that. So they have the opportunity to charge them for that and get paid, because, of course, they're the only ones that they have any odds against. So the owner of a separate unit shall follow documents, and I like this term. They took out the time frame and they call it practicable, right? So before the transfer of title. So that's how long I have to get it to you, as long as it is practicable. This form is the exact form that they have in the civil code, and it's very detailed, as you can see. So whoever fills it out has to let them know who they are, their relationship, and specifically what information you have and you're asking for. Also, you don't have to ask for everything. I'll give you a one. I don't really see the articles of incorporation as a big issue, right? Because most of them are just single page, and they're just basically tell you when the developer started the process. It's the CC&Rs that tell you what you can and can't do on that property. It's the bylaws, it's the rules and restrictions that you want the most updated copies. So yeah, by all means, get copies of that. Also the financial information, right? Well, a lot of this information is year to year, right? So if the seller has their information from a couple months ago, your reserve study hasn't changed. It's an annual document. So if they have a 2-month-old reserve study, no problem. Let's take that. So know what documents are there and available via the seller, and then you don't have to order every single document on this list, but you certainly want up-to-date documents. And with that, we are ahead of schedule. I'm going to take a real quick look in the Q&A section, see if there's any burning questions. No, we had 4 and they were answered by somebody who was nice. So thank you for doing that. So with that, I would like you to introduce you to AJ Scott. She is with the Klein Insurance Group. She's been a member of CAI as well. I won't say as long as I can remember, because that would be inappropriate, but she's been a member of a long time. She has completed her CPCU designation in 2014 and was recognized as the distinguished graduate. In 2019, she earned her CIRMS designation, was what the insurance professionals do in this industry. I know that you in the real estate industry love your acronyms after your name, which are well earned. So she has earned the highest designation there is for an insurance professional. And since joining the Klein Agency in 2006 as an entry-level capacity, she is now Associate Vice President, and she co-chairs the Education Committee, or previously co-chaired, the Orange County Education Committee, and she served as the CAI Law Seminar Planning Group since 2018. So with that, I will turn the insurance over to the ever-confident AJ Scott.
Thank you, Scott. And I want to recognize Karen Thompson. You guys can see her on our panel. She's been responding to your questions. She is a very experienced PCAM Community Association Manager. So we'll introduce her formally in a few minutes, but she's just, you can see, listening to Scott go through those laws and all that California requires of community associations, you can see the need for professional management, because board members are volunteers. They need partnership. They need help to navigate these waters. There's really a lot going on here. So insurance as well. I mean, we could spend 2.5 hours just talking about insurance. We're not going to, but you can see how a professional manager is really an enormous asset to community associations. They will be a great resource for you all as you're doing these deals. I'm sure you've interacted with many of them. So let's get into the insurance segment. Just like Scott was talking about various sources of authority for the laws that govern community associations, there are various sources of authority for what insurance community associations must purchase. So let's go to the next slide, Scott. These sources include the Civil Code, the Davis-Sterling Act that Scott had mentioned a few times as we were going through the legal portion. The Davis-Sterling Act has some sections that do apply specifically to insurance that must be purchased by associations. Those sections are found in the 5800 section, one of the shorter sections, thankfully. So just 5800 through 5806 or through 5810. That talk about what insurance must be maintained and what must be disclosed with respect to insurance. Those statutes are obviously going to apply to every association statewide, whereas governing documents are going to differ from project to project. And we'll get a little more into these. We won't spend a ton of time, but and then of course lenders have insurance requirements that must be complied with in order for sales and refinances to happen within a community association. So let's go to the next slide. We'll talk just briefly about the Davis-Sterling Act. We're not gonna, you all have a copy of these slides. I'm gonna let you read through the language on your own, but just suffice it to say that there are specific requirements in the Civil Code respecting the directors and officers liability insurance, the protection for the volunteer board members' decisions that they make on the HOA's behalf. There's a specific requirement with respect to the general liability insurance that must be maintained by the association, general liability responding to third-party damages that may be incurred because of the association's negligence, because of that standard of care that Scott was talking about. So there's requirements for the D&O, for the GL, and then the third one on the next slide is fidelity insurance. So crime insurance. HOAs must maintain insurance to protect their funds against theft and embezzlement losses, okay? And that was because of a series of events that happened in the state several years ago. The legislature responded by making crime insurance mandatory. So let's move on to a discussion of CC&R insurance requirements. Most CC&Rs, but not all, contain an article specific to insurance, what the association must purchase and what the individual owners must purchase. So if you're working on a sale within an HOA and your borrower or your buyer, excuse me, is asking you, or your seller, what do I have to maintain? What does the association have to maintain? The first place to look would be those governing documents, that insurance section. It's often spelled out, but not always. It's certainly going to vary based on the legal ownership interest. Like Scott was talking about the various types of associations and how we have construction terms like townhouse, but then we have legal forms of ownership like condominium, planned development, cooperative. I want you all to take away from this presentation that you don't know the legal form of ownership just by looking at an association. An association might look like a condo, it might look like a townhouse, it might look like a single family home community. That doesn't necessarily mean that the legal ownership interest that each owner has in the project follows what it looks like. Often we'll see townhouse associations that have party walls. There are maybe a building of 5 units with side-by-side units that share walls. It might be a planned development. Each of those 5 owners in that building might legally own the lot that they're sitting on, and they might be responsible to ensure their entire home, even though they share a wall with their neighbor. That wall is going to have duplicate insurance, and that's just the way that goes. But that does happen. So always know that the only way to know the legal form of ownership and what's required is by looking at those governing documents. That's the ultimate source of that information. So in terms of insurance and what's required, there are two sections of the CC&Rs that may come into play. There's going to be the maintenance and repair obligations, and there's going to be the insurance obligations. Often there won't be perfect agreement between those two sections. When there is disagreement, we prioritize, as an insurance practitioner, I prioritize the insurance requirement. If one of them is going to be broader, I can tell you it's going to be the insurance requirements. If an association is required to maintain broader coverage than they are actually required to maintain, repair, and replace, that is common. It does not go back the other way. There will not be situations in which the association is required to maintain narrower insurance coverage than their maintenance and repair obligations. So we're looking at those things when I go to quote an association or to review their coverage. Those are the sections of the CC&Rs that I'm looking at. So let's go to the next slide. Of course, we have our lenders, and they have their requirements. And why do the lenders care what the association maintains? They're not, the HOA is not their borrower. So why does it matter? Well, there's two things that they're concerned about when they impose these restrictions and these requirements on HOAs. They're concerned, of course, about their collateral. That's the obvious thing, right? They want to make sure that the property is protected. If something happens, that property will be restored. Their collateral will be will perpetuate, will go on, and that is preserved in the interest of securing their loan. The second item, of course, is their borrower's ongoing ability to pay their mortgage. And that's where all of their other non-property insurance requirements come in. There are requirements for the HOA to maintain certain liability insurance coverages, crime insurance. The reason they're requiring those and so concerned that the association maintain those other coverages that don't seem directly related to what they're doing is because if the association maintains inadequate insurance and something goes wrong, who pays? The homeowners. There's going to be a special assessment, and the homeowners will be called upon to make up the shortfall if there's inadequate insurance coverage. And if homeowners are having to respond to unexpected special assessments, they're less likely to make their mortgage obligations. They're not going to maybe have the financial wherewithal to respond to that monthly mortgage commitment. So that's why lenders care so much about what insurance coverages HOAs maintain. So let's move ahead. So insurance policies are typically going to fall into one of two avenues. They're either going to be property insurance policies, which of course refers to the real estate improvements, but also money. Money is property. And then there are liability insurance policies. So let's break that down just a little further. With property insurance, you're protecting your first party interests. So you are your own first party. I am my own first party. When I buy a property insurance policy, I'm protecting my interest in my property, in my money, in the things that I own. If I have a loss, it's going to cause me financial hardship. That's what that insurance is for. The loss needs to be fortuitous to be insurable in most cases. It can't be something that you could have reasonably expected, right? Scheduled roof replacements are not an insurable loss. You need to plan for that. So whereas if lightning strikes your roof and you need replacement, that is covered. So that's a bit about property insurance. Liability insurance, this is third-party protection. This is if I am at fault or accused to be at fault for a third party's damages, for their bodily injury or their property damage, for their financial loss or physical, mental, emotional loss. So this does include hurt feelings. That's a type of, even though we wouldn't consider it a bodily injury, it is a type of third party loss. And there's a need for the injured party to prove negligence. So Scott was talking about the standard of care and that reasonably prudent person standard. There's a reasonably prudent association standard. And if HOAs fail to meet that standard, they may be liable for a third party's damages. One of the trickiest things about homeowners associations is that each and every unit owner is simultaneously a first party in some cases of the HOA And at other times, they may be a third party when they are, when they set themselves up in an, I cautiously use the term adversarial relationship with the HOA, but when they distinguish themselves apart from the HOA and they make a claim against the HOA so that there's a clear separation between the two entities. So you might see a unit owner involved in a first party property claim and a third party liability claim. And it can be difficult to sort these things out. So let's go to the next slide. But just bear in mind that both are going to be applicable to each and every buyer and seller in an HOA. They might be a first party, they might be a third party, depending on the circumstances. For property insurance, there's four big policies that we see. And that's your fire insurance is kind of what we colloquially all call it, but of course it covers more than just fire. We call it a special form policy. Special form means that every peril that's not excluded in the policy language is covered. It's a really broad coverage, and that's why sometimes we call it the master policy, because it's so broad, it's so encompassing. So everything that's not excluded. So there are some things that are excluded that you need separate policies for. Of course, earthquake and flood, given that they're catastrophes, must be addressed with separate policies. In California, earthquake always has to be written separately from the master/fire insurance. Fidelity crime is in here too, because that protects the association's money. Money is property. That's that first party financial loss we were talking about. So fidelity and crime insurance is a property coverage. So let's go into what are the liability policies that we're looking at. There's a whole bunch of them on the next slide. These are those third party losses that we were talking about. Of course, the first one is your general liability insurance, and that is to insure third party. Oh, I'm sorry. You know what? I skipped a couple slides. Let's go back. Go ahead, Scott. Let's take us to the walls in slide. Sorry about this, guys. Forward. We're going to talk about we're going to spend just a couple minutes talking about walls in coverage. I know you all have heard this term probably a lot as you're doing deals in HOAs, and it's this big question of where does the association's coverage stop and where should the homeowner's coverage begin? What is that dividing line? So we have, I think it's slide 44, Scott. So there are four types of, we call them condominium insuring agreements. This is specific to condos now, or to associations which insure as if they were a condo, which does happen sometimes. When it comes to permanently installed fixtures and finishes inside the unit, there's a big question of who insures those. There are four types of policies that HOAs can maintain with respect to those improvements. The first one is the most confusing. It just points to the CC&Rs and says, whatever the CC&Rs require, that's what we're going to cover, which is hilarious because the insurance carrier has never seen the CC&Rs in most of these cases. So they don't know what they're insuring. You don't know what they're insuring. If the CC&Rs are not clear, that's a big problem. So in recent years, we have seen it becoming much more mainstream, much more common, much more easy to obtain what we call affirmative insuring agreements for that interior property. And these are clear. They do not tie back to an unseen document that's buried in the CC&Rs. They simply say, this is what we are covering. And so the next three that are listed on this slide are those three affirmative insuring agreements. You can have bare walls, that's up to and including the unfinished surfaces of the drywall that bounds each unit. So it's ensuring that empty box, all the structural elements, the hallways, the stairways, the elevators, all of that is going to be covered by the HOA's policy. But when it comes to inside the individual dwelling unit, it's just an unfinished box. And the unit owner is going to be responsible for ensuring everything inwards of that. So when you see the term bare walls, you know that your buyer is going to need a lot of their own real property coverage or building property coverage or coverage A under their HO6 policy. That's the condominium unit owner policy. Single entity, I prefer the term original builder's specifications. So that's going to fund, sometimes that's called walls in excluding upgrades. it's going to pay for restoring that unit back to the kind and quality that it was when the developer originally conveyed it to the first owner. It doesn't mean that you're required to rebuild that way. It doesn't mean that the owner is going to be forced to put in the builder grade materials that were there in 1974 when that building was originally built. It just means that that's what the HOA's policy is going to fund. And the difference between that level and the finishes that were there before the loss that may have been upgraded over time by various owners, including the current owner, that difference between developer and current is going to have to be insured by the owner themselves. So they can get coverage under their HO6 policy to fund the cost of upgrades that have been made to that unit over time. All included is the broadest one. As you can see on the slide, everything that wouldn't fall out if you were to turn the building upside down and shake it is covered under an all-included policy. All of the upgrades that have been installed over time, the master policy held by the association is going to pay to restore it just as it was before the loss. However, it's going to be subject to the HOA's property deductible and the policy limits that the HOA maintains. So what does that mean? You can see a line at the bottom of the slide. How is this different from HO6? Please know that every condominium unit owner always needs an HO6. How much coverage they need under their HO6 is going to vary depending on what the association maintains, but every homeowner needs their own insurance policy because they are both a first party within the association, but they're also a third party, like we talked about. They have separate and distinct exposures from the association that they need to insure individually. Let's go to the next slide. We're going to talk very briefly about HO6 and HO3 policies. These are the individual homeowner policies that every owner needs to maintain. Regardless of what the HOA covers, you still need your own coverage to supplement that protection. So there's several pieces of an HO6 or an HO3. The building property is going to ensure those permanently installed features to the extent that the HOA doesn't. And there's always going to be, even on an all-included policy, the HOA's deductible sometimes, you guys have probably seen, sometimes it's $10,000, $25,000. That means anything below the HOA's deductible is not covered by the HOA's insurance. So the homeowner definitely needs building coverage for at least equivalent to the association's deductible, and sometimes higher if the HOA maintains builder specs coverage or bare walls coverage. Personal property, everything the owner can pick up and move around inside their unit, that's never covered by the HOA. That's always the owner's responsibility to insure. Personal liability, that's liability inside the home for anything that might go on inside the airspace that the owner owns, or your activities outside your unit that are specific to you and not specific to the HOA. You need to insure those. If I'm out walking my dog in my HOA's courtyard and my dog attacks someone, that's not the HOA's responsibility to insure. That's my responsibility. In California, animal law says I'm responsible for my pet's behavior. So that's going to be covered on my homeowner's policy, not the HOA's policy. The HOA doesn't own my dog. Loss of use. If you have to live somewhere while your unit is being restored back to a habitable condition after a fire, for example, you need a motel, hotel, apartment rental. That coverage is insurable under loss of use. If you rent your condo, that can be written as loss of rents coverage to restore your rental income for the time that you cannot rent that unit. Loss assessment coverage, if the association's insurance limits are insufficient for any covered loss, they may levy a special assessment to the membership to make up the difference. Loss assessment coverage is what is going to protect you and fund that special assessment in that scenario. This is going to be most common in liability circumstances. If there's a really horrible loss, an emotional loss, a drowning in the swimming pool, a spinal injury, anything involving a child. If someone gets seriously hurt and their damages are higher, or their settlement or judgment awarded is higher than the HOA's insurance limits, there's going to be a special assessment to make up the difference. And that special assessment can be tendered to a homeowner policy via the loss assessment coverage. So that's really important, whether you're living in a condo or a single family home community, you really should look at loss assessment coverage, especially if your HOA has amenities like swimming pools and sports courts and playgrounds. It's really important. I list comprehensive auto coverage on this slide because if a tree branch falls and hits your car, the HOA might own that tree. It doesn't mean that they're responsible for that tree. If they didn't know that the tree was in poor health, and if they didn't fail to exercise that reasonably prudent person standard that Scott was talking about earlier, they're not negligent. They're not required to intuit the health of every tree on the property and prevent that from happening. So if you have comprehensive coverage under your auto policy covers that. You own the car, you're responsible for damage to the car unless someone else's negligence causes that damage. So obviously fires, earthquakes, a lot of times the HOA is not negligent. They're not responsible. You can get coverage under your auto policy for those losses to your vehicle. So let's move ahead. Fidelity crime, like we talked about, this is for the association's money. And we're not going to spend too much time talking about this, but again, the reason that this is important for unit owners, that the HOA has adequate crime insurance, is because lenders require it and the civil code requires it. So there was a rash of theft and embezzlement losses about, what do you think, Scott, like 5, or Karen, like 5, 6 years ago? There was just, one after another, and they were very public and it was high profile, and the legislature said we can't have this keep happening. We obviously can't control human behavior, we can't stop people from misbehaving and stealing, but we can make sure that these HOAs are protected from the financial fallout resulting from those losses. So we're going to require HOAs to maintain fidelity crime coverage. We're going to require it up to specific limits. And we're going to require computer and funds transfer losses because cyber crimes are becoming more and more prevalent. And we want to make sure that these HOAs can continue to function and that homeowners aren't penalized for losses to HOA funds. Because if there's not adequate insurance, who makes up that difference? Who pays for those lost funds? It's going to be the membership. So there are specific insurance agreements. All of this should leave you with an important takeaway. It's really critical, just like we were talking about. It's important to deal with an attorney that specializes in HOA laws. It's important to partner with a professional community association manager that's familiar with all the HOAs entail because they're so complex. Insurance brokers who specialize in HOAs know these requirements. They know what HOAs need, and it can be pretty complicated. So it is important for HOAs that you're involved in or that you come across. CAI is a great resource for connecting you with all manner of vendors that really understand HOAs. So let's move on to the next slide. Liability insurance. Of course, there is general liability. The most common occurrence where you need general liability coverage is the slip and fall, trip and fall. Like a sprinkler head is broken, it's spraying water over the sidewalk, somebody walks along and slips and hurts themselves. That is one of your more common general liability claims. Probably the most common liability claim that we see is the vehicle entry gate, hitting vehicles on their way into or out of the community. Karen has seen this a lot, I'm sure. We see this all the time. So yeah, it's important for HOAs to maintain their property very vigilantly and carefully to ensure that there are not these potentials for third-party injury or property damage. Personal or advertising injury, this is hurt feelings. Advertising injury doesn't happen too often in HOAs. That's like copyright infringement, those types of losses. But personal injury, this is defamation, invasion of privacy, wrongful eviction. Those types of claims can happen in HOAs. We have seen them, unfortunately. Products completed operations, this is uncommon for associations. We don't see these types of claims because HOAs are not manufacturing anything. You might have someone get sick off of cookies that were served at a board meeting, and that's your most likely products liability claim at an HOA. It's very uncommon. Medical expenses is a coverage within the GL policy that pays a finite amount for direct and documented medical expenses, regardless of fault. So this is the one exception that proves the rule. There's no need to prove negligence for this medical expenses coverage. usually only covered for $1,000, $5,000, or $10,000 per person. But the idea is somebody slips and falls on that wet sidewalk, show us your medical bills, we're just going to pay them for you. And the reason that the insurance company wants to do that is to promote goodwill. They want this to not escalate into a lawsuit with attorneys and legal fees that Scott was talking about that get higher and higher and higher. Every general liability policy, every liability policy has both a defense provision, the payment of defense costs, and what we call an indemnity provision. And that's the amount that's reserved for a settlement or a judgment or damages to the plaintiff or the claimant. So sometimes you can rack up extensive defense costs, even if there's ultimately no indemnity awarded to the plaintiff. Like Scott was talking about, a lot of times the plaintiff would be responsible for paying those defense costs in that scenario. But while they're being accrued, you want insurance to pay for those. And most well-written liability policies, regardless of which one they are on this list, are going to pay those defense costs. So you can see there's many coverages listed here. You have automobile liability. Not a lot of HOAs own autos, but the ones that do definitely need auto coverage. Directors and officers liability, this protects the board. Umbrella insurance, this is excess liability. This doesn't extend over property coverages, it's only over liability coverages, but it provides higher limits for those very rare but very upsetting claims that are very serious, like we talked about. If there's a wrongful death on the premises or a permanent disability, those are going to be much higher than your 1 million, 2 million per occurrence. You're going to need higher limits for that. So that's where the umbrella comes in. Workers' comp, of course, is required by law if you have employees. If you don't have employees, there are still situations in California where you might be unexpectedly deemed an employer. So HOAs often will maintain a zero payroll workers' comp policy just as a safety net. We have a slide on that later, but we're not going to spend a lot of time on it. Just know that you might see workers' comp under an HOA that doesn't have any employees, and there is a reason. Cyber liability is becoming more and more of coverage that we talk about, that we didn't talk about 10 years ago, but we're talking about a lot now. Cyber liability, think of that in terms of data and privacy. Don't think about it in terms of cyber crime like theft of money. That goes under the crime insurance, that's a property coverage. But in terms of if you don't protect your data well enough and it gets out, you have a breach, you might be liable to the parties whose information you have exposed. You need coverage for that. As an HOA, you have people's names, addresses. If you do have employees, you have social security numbers and other sensitive information. You might have credit card numbers in the software that you use or checking account numbers in the software that you use to collect dues virtually. All of that might come into play in a cyber liability policy. A lot of the better D&O policies include some limited cyber liability protection, so there is coverage there. Employment practices liability, if you have employees, you need coverage for claims that allege harassment, discrimination, wrongful termination, negligent hiring, those types of claims. In California, that's really important. There are a lot of laws governing employers, so employment practices liability is really important. So let's move ahead. Additional insured requirements. You probably don't deal with these too much in your standard day-to-day. They might come up from time to time or in your own experience with your own HOAs that you live in, or if you've ever served on a board, you may have run into this. Homeowners in the community should always be additional insureds under the policy with respect to the ownership, maintenance, and repair of the common area. If someone slips and falls in the common area and it happened right in front of Unit 27's front door, and that person sues Unit 27 and the HOA's policy needs to provide defense, not just for the HOA, but for Unit 27. We have, thankfully, statutes in the California Civil Code that shield unit owners from those types of claims if the association maintains adequate general liability insurance. So take a look at those civil code slides from the beginning of the insurance section to look at those details. But The community manager is also entitled to being named as additional insured because they are acting at the direction of the board. So the board is telling the community manager, this is what we want done. The community manager is doing it. If somebody doesn't like what they're doing, they're going to sue the association, the board, and the community manager. So the community manager is entitled to defense under the association's policy for those types of suits. The association's policy is not responsible for defending a community manager if they go rogue and do whatever they want, not at the direction of the board. The management company has their own errors and omissions coverage for that. So that's not what we're talking about. So I know sometimes people bristle, why do we need to extend this coverage to the manager? Well, it's because they're your agent. They're acting at your direction. It's appropriate. It's built into the contract. You need to fund it with your insurance policy being written correctly. So let's go to the next slide. And I think we're just about at the end. We're not going to spend a lot of time talking about the board's coverage. Suffice it to say, there are better and worse D&O policies. And since if you've ever served on a board, you know that it's a thankless job. You don't get paid enough to take big risks with your decision making on the HOA's behalf. You're not actually paid anything. It's appropriate for the association to maintain broad, comprehensive directors and officers coverage. They shouldn't be buying the bottom of the barrel, absolute cheapest D&O coverage. It doesn't mean they need to spend a fortune. D&O policies are not, the really nice ones often are around $1,000 a year. So we're not talking crazy amounts, but it is appropriate to, especially in California where our legal climate is energetic, it's important to make sure that the board has appropriate coverage under the D&O policy. So policies differ from one to the next. It's good to ask a broker, you know, how is our D&O protection? Workers' comp we talked about, so we're just going to move ahead and get into finance. So I will let Scott introduce Karen. Thank you for having us.
Thank you very much, AJ. We appreciate that. I don't see any insurance questions, so you did such a good job that there were no questions. If you do have questions for AJ, you can find her on cai.org. That's the CAI website, her and others, and she's available at AJ at the Klein Agency. So if you have more questions for her, by all means, do it. And so with now, and we're very pleased to have Karen Thompson here because we don't always have a community manager with these programs. So this is somebody who can offer you a lot more in the operations and the day-to-day where the rubber meets the road kind of thing. Karen is the director of large-scale management for Keystone Pacific Management in Huntington Beach, one of the most experienced firms in the industry, having serving clients in Orange County since 1982. Dating Karen a bit, she has been with him since 2011. And herself has achieved the CMCA, AMS, and a PCAM, which a PCAM is the highest level designation you can get in our industry. So despite her youthful appearance, she has a lot of experience and the credentials to that. So with that, the finance section with Karen Thompson.
Great, thank you, Scott. And yeah, hey, it's my pleasure to be here. This is such a wonderful program that I'm proud to be a part of and here to share whatever knowledge I can from the side of the, you know, as you say, kind of the nuts and bolts of the HOA world with working closely with our board of directors and how they function. So again, thank you. And I thank you all for being here. There's a lot of information in this program. So please feel free to reach out with questions. Happy to help answer those. So let's move ahead to the next slide and we'll talk about finance, which is an important element to the management and function of a homeowners association or a community association. And I think that it starts with the basis of your board of directors. And as we've touched on throughout the morning, your board of directors in a community are volunteers. They're unpaid homeowner volunteers. So they do have their stakeholder. They have a vested interest in the community and they are not paid. So they're not what we would consider to be an expert. They rely on experts within the industry with their insurance brokers, their legal counsels, their professional managers. So they rely on the expertise of those experts around them. Part of the board of directors' responsibility is to levy and collect assessments. It's not always popular, and especially when we have to raise the assessments, as we're seeing more and more in recent years that costs are going up, insurance is going up, everything is going up. So as it follows, so do our assessments. But it is a big source or a big responsibility on the board of directors. They are running a corporation. And as much as we have kind of that personal element with our neighbors, a board needs to remember that they are an officer of a corporation and need to treat that responsibility with with a lot of conscientious background involved in the raising of dues or keeping dues the same. So the governing documents gives the board the duty and that responsibility. You'll find that in the CC&Rs and also the civil code. They also have the duty to manage the HOA finances and that fiduciary responsibility. We hear that term a lot. Most boards and that I've seen over my 30 plus years take that responsibility very serious. And they look very closely. Oftentimes, they will require that a manager obtain 3 bids before they make an expense. They really want to investigate and look into the expenses. That's really the crux of an HOA is their expenses. We're not here to produce income. We're nonprofit. We're not looking to make a profit. We're just looking to cover our expenses. So a board should look very closely at their finances and what they're spending. So that takes us to our review. The next slide. Thank you, Scott. The financial statement. So typically, I like to think every HOA uses a professional management company, but if they don't, they're required to have some basic financial statements available to them to help figure out what their expenses are, what they've spent, what they've budgeted, what their income, what they're bringing in. So that will include a balance sheet. Most financial statements that we're all familiar with include that overview snapshot of our cash, our reserve funds, which we'll get into in a little bit. Big important element as to where we financially stand in that snapshot. Income and expense report will show the difference between, or will show the income that's come in and the expenses that are going out. We love to think that they're balanced. Oftentimes they're not, but a board should be reviewing to see where they stand with their expenses each month. The check register will detail typically in a 1-month period, but you could also look at it on an annual basis, the checks that have been written during the past month. And that will show, your checks to your landscaper, your plumbers, etc. General ledger detail breaks it out by a general ledger or a coding number. 4100 may be landscape, 4200 may be insurance. So it'll break it down by the general ledger detail by each account that it's allocated to within the financial statement. Reconciliation report is just like we all do with our checkbook, is we reconcile it. We look to make sure checks have come in, that deposits have been posted and made. So it is that, again, that recap of the month. Continuing on with basic financial statements, general journal entry report will show any credits, debits posted throughout the month. Prepaid report and a delinquency report. These will be available to a board of directors typically, and especially with the delinquent report, it's not always published to the membership. So your membership or a member of an HOA, a homeowner, is entitled to review financial statements, but not all of the details of that financial report may be included to them. And that would fall basically the delinquency report, as it contains personal private information. But the board of directors would certainly be viewing this in their monthly financial report. A prepaid report showing prepaid assessments, and a delinquency report would be showing who hasn't paid those assessments. The annual budget, ever popular, and something that if you're a member of an HOA, a homeowner in an HOA, you'll receive a giant packet in the mail once a year, and that will contain the operating budget. There's a lot of, it's probably one of the biggest things that an HOA will do and produce throughout the year, and it is that guideline for the future of what we're going to anticipate spending, what we'll anticipate bringing in for income. And it is also disclosable to the membership. So the membership will see what the board has in store for the next year with regards to the finances. So it does, so the operating budget produces or is the needs and policies and goals of the HOA for the fiscal year or the upcoming fiscal year. What do we need? Are our prices going up? Has our landscaper increased their service contract price. Also goals for the HOA. Are we planning to build a new golf course? So there may be funding requirements that would also be included in the operating budget. Anticipated income, again, I look at a budget, I kind of flip it around. I look at what my expenses are. That's going to determine what my income is. Where can I cut my expenses if I can, to help keep those assessments as low as they possibly can. Oftentimes, I'm just going on a personal plug. I'm just going to say a lot of times a board of directors really have that goal. They want to keep assessments low. They don't want to raise the dues of their neighbors and their friends. And I understand that, but oftentimes it's not the best course to take. Again, it's a corporation. And if our expenses are increasing and we're not raising our assessments to keep track with that, we're really doing the community a disservice. And if I can't pay my expenses, I can't fix things such as maybe a stair rail that's loose or broken. I can't maintain the property. So we really want to make sure that we are adequately funding and budgeting for anticipated expenses along with our unexpected expenses. Reserve allocation or reserve fund allocation, that's our future spending. We'll get into that in great detail coming up, so I won't spend any time there, but that's our savings account for future spending. So what must be in an operating budget? Estimated review and expenses on an accrual basis. It's the month in which that it's earned. It's not necessarily always a cash basis where we're most familiar with our own checking account. I know what's coming in. I know it's going out on a cash basis. We typically use an accrual or a modified accrual. Reserve funding must also be in the operating budget. And just to touch on quickly, as a manager from where I sit, I need to know what my reserve study shows and tells me. That's my guide that I'm going to follow in preparing the budget and advising a board of directors on what their income or assessment level needs to be based on what that reserve study is telling me for future spending. Again, Scott is the expert to talk on that later, so I won't spend any time on it. Won't even begin to cover reserves. The annual budget limit on the board of directors. So I see a lot of times in HOA, and I've been doing this long enough, that the board of directors aren't, again, let's remember they're an unpaid homeowner volunteer. This is not always popular, and especially if we have to increase our budget amounts or increase assessments. But the board does have a limit per the civil code on what they can do. So regular assessments increase is limited to up to 20% increase without membership approval. It's pretty liberal. It's pretty, but it also is said in the civil code that they can't increase 75% without going to the membership. It may come to that need. And again, you would have to put that out to a vote of your membership so that everyone can have a say in a decision. But the board without membership can go up to 20%. And oftentimes, especially now, if you haven't raised assessments over the last 4 to 5 years, you are at a state where you are probably gonna have to go up 10 to 15% just because the cost is going up everywhere. Special assessments, that's that unanticipated need. Perhaps there's been an occurrence. I've been hearing rumors of folks in fire zones that their insurance is increasing because of that. And so it wasn't something that was budgeted and anticipated. So some communities are looking at doing a special assessment to offset those increased either budget items or non-budget items. So a board can do a special assessment of up to 5% of the budgeted gross expenses for the current fiscal year without membership approval. Some communities like to do maybe a capital improvement or an improvement to the property, and that may also require a special assessment for which you'd have to go out to the membership to make sure everyone approves that. An emergency special assessment, the board of directors do have that unlimited authority as an emergency. Okay, borrowing from reserves. It's easy to think, okay, I've got this cash pile sitting over here that I can tap into, but California Civil Code, and I should say California has one of the best written laws that I've seen that manage and govern HOA. So it's helpful to rely upon what we find in the Civil Code. And Civil Code 5510 states the board of directors shall not expend funds designated as reserve funds for any other purpose other than the repair, restoration, replacement, or maintenance of components for which the reserve fund was established. So I've set aside that money for future expenditures or future replacement items. I can't use it to build something that I want that I don't already have contained within the property. So I may want that new pool, but I can't use reserve funds because it's not designed and established for that purpose. However, Civil Code 5515 goes on to state that the board may authorize the temporary transfer of monies to meet a short-term cash flow requirement. We see that pretty often, but they must repay that within 12 months. And there needs to be a plan in place to repay those funds. Because again, we're borrowing against money that was really designated and set aside for future spending of a component, such as a roof or painting. Annual reports. The board of directors or the HOA is required to produce several documents throughout the year. The budget is one, and the year-end financial report, or what we often call an audit, is required by the Civil Code. The annual policy statement basically covers a lot of details that homeowners need to be aware of as it pertains to their association, such as where to find notices, meeting notices. The board typically meets monthly or every other month or quarterly. Those meeting notices need to be posted in a location. You'll find that location in the annual policy statement, along with where to make payments to, perhaps even the delinquency statement, or the delinquency policy, I should say. What happens if I can't pay my HOA dues? That delinquency policy is disclosable and is sent to the membership on an annual basis. The annual budget report, again, I'm required as a HOA or a board of directors, I'm required to publish and submit or send out the upcoming fiscal year budget. Civil Code has some timelines that we'll get to here in just a minute, but that's required to go out. And then the year-end financial report we'll touch on here in just a moment as well. That is, again, an audit or a financial review of where we ended up. So our timelines, the annual policy statement, Civil Code tells us it must be distributed 30 to 90 days before the end of the fiscal year. Typically, we tuck it in with the budget, so it makes that really big, thick packet that comes in the mail. Some homeowners associations are looking at ways to streamline that, maybe publish it more online because of the size and the cost to mail every year. The annual budget report, again, also 30 to 90 days before the end of the fiscal year. You have to know what's coming up, what's ahead, and that budget will tell a homeowner what their dues will be in the upcoming fiscal year. Pro forma operating budget, reserve study, funding plan, financial statements and reports all should be included in that budget. Any what we call disclosures, your insurance would also be included in that packet. So it's oftentimes kind of put aside because it's big and overwhelming, but there's a lot of good information into it. So keep it, refer to it, because you never know when a question may pop up. Yeah, either a full report or a summary or consequences to fail to distribute timely, is all outlined in the Civil Code. So if the board is not getting their packet together or their management company is not putting that packet together, there is some consequences for that outlined in the Civil Code. So it is a deadline that we strive to make every attempt to get that out in a timely fashion, because the consequences could be detrimental back to a board of directors. The year-end financial reports is, again, that audit or that recap, that financial review of how we ended up the year, how things look. It's usually prepared by a CPA or an outside third party. It must be distributed within 120 days after the close of each fiscal year. The gross income exceeds $75,000. You must have a licensed California certified public accountant. And again, there's a difference between an audit and a financial review. Most boards kind of make that decision based on their gross income. And that concludes, I believe that's the last of my slides.
Thank you very much. We appreciate that. And just so you guys know, from you want to see your money at work. So a new law this year, because we've talked a lot about these disclosures, and as you mentioned, these documents can be very thick, hundreds of pages sometimes. The Civil Code does allow for associations in many instances to provide a summary. So now, based on the input from the real estate lobby, a summary of the report is defined as a summary of the report that includes the first page, a general description of the content report instructing, printed at 10-page bold-faced type, regarding how the request to comply with the report at no cost to the members. So if you do see a summary, now it's required to be in pinpoint bold type, what that summary consists of, and how you can get a full copy of the report. And as Karen mentioned, a lot of associations are going to Dropbox scenarios or leave it on their website or a large PDF, because yes, it's a large package physically mailed. So again, thank you very much, Karen, for that. And as we get through this program, there's a lot of thought. You're like, how do I know all this stuff? CAI.org. That's how you know that stuff. Send your clients to somebody who knows more. I can tell you in the industry, we have what's generally known as the 15-minute rule. If we've published a document or somebody has our product, we'll give you 15 minutes to talk about it. If you need a more lengthy explanation or you have a lot more questions or a group of people, yeah, they might charge for that. But if you have a copy of a document, most people will give you 15 minutes to explain that. So your members and your prospective clients should be able to do that. All right, let's talk a little bit about maintenance. Two kinds of maintenance that there are in associations. One is an operating expense, the other is reserve. So as you would expect, the operating or routine happen on a regular basis. The reserve expense are infrequent. So whether it's a roof, plumbing, etc., they're done. It's very important that they be through regular contracts. HOA should not sign any contract without having it thoroughly reviewed by a legal counsel. So when you have a lot of routine stuff, that's why it's good to have a routine maintenance contractor. So you can have a standing agreement, a standing contract, so that they can go out and fix a number of things. You don't have to go through this review process every single time. Also, as we talked about, there are various codes and so forth. The corporation's code does not provide a lot of relief for failure to maintain a property. That's the entire function of a board of directors, is to maintain the facility. So if you serve on a board of directors and you allow that property to fall into disrepair or lose significant value outside of external circumstances, you probably don't have a lot of liability coverage in that. Well, now we're here to our favorite part, the reserve study aspect. And I say that because I'm a reserve analyst. And this is, again, the finances of the HOA. And quite frankly, one of the most important decision factors that somebody's going to make when they make this investment decision is how well prepared are these folks for the future. So a reserve study is made up of two parts. You've got the physical analysis, which is the property itself, right, and its components. And then you have the financial analysis. How much money do they have? What's their income stream? How much are they expected to spend? So the idea of reserve study is to merge those two processes and to give you a complete evaluation of where you are both physically and financially. Made up of other parts. One is the component inventory. That's simply the list of the components that the association is responsible to maintain. This will stay relatively stable from year to year because not much changes, right? Your roof is going to stay there for a long time. You replace it, okay, it gets replaced, but you don't change the number of water heaters. You don't change the number of other items. So it's going to stay relatively stable from year to year, just adjusting the life expectancies and, of course, the cost. And the condition, of course, will change from year to year. So either it's a year older or 2 or 3 years older, whatever time has elapsed. And of course, the life and evaluations will change. So each year, as you've probably known, costs are going up. This year more than normal. So we have to reevaluate at a cost. And some are very volatile. So for instance, asphalt. Well, asphalt is, of course, based on the underlying cost of oil because that's what it's done. So, you may have an oil cost that goes up, which is going to increase your cost for asphalt. And if it goes down, it will have subsequent. So those will vary greatly from year to year, again, based on the underlying commodity. Some terms that they use out there, one is called percent funded, and that's a finding of the client's current status. And that's to give you what they call an order of magnitude. So let's say hypothetically, you have a water heater, it lasts 10 years and costs $1,000. So it depreciates at $100 a year. So after 5 years, you should have $500, not the full amount because you're not expected to replace it for 5 more years. So if you have $500 at that point in time for that, you are in fact 100% fully funded. And that's the same calculation for each component. We've got other slides on that later. And then it must also include a recommended funding plan. So a recommendation for how you're going to deal with these future costs. So you have your current cost, the operating stuff that Karen just spoke of, and then you have your reserve expense. And again, these are volatile. Some years you spend a lot of money, other years you spend less money. So a reserve plan will tell you how much money you need to set aside on an annual basis to make sure you can handle these spikes in expenses. And we have some more graphs on that in just a second. So essentially what it's going to tell you is what's the HOA responsible for, how long does it last, what condition are they in, how much does it cost right now, what is our current status, where are we at, and then the most important information is how do we pay for this moving forward. There are 3 types of studies. One is a full study, and as the name would imply, it's everything. You go out to the property, you identify the components, you quantify them, you provide a condition assessment, life expectancies, cost, extrapolate that out and produce a funding plan. Full study. If done correctly, you only have to do that one time, because after that, you're going to update it, right? You already have your component inventory with all the information in there. So now you just need to update that information. That's known as an update with site visit. They require that in California for HOAs every 3 years. And then they require an update without site visit, often called a financials only or a desk consult. And that is they don't go to the property, they don't reevaluate the components, they just simply remove the elapsed time, 1, 2 years, whatever it may be. They readjust the life expectancies. They readjust the cost based on the new cost. They talk about whatever the new contribution rate is and the new beginning balance, and they extrapolate that out over the 30 years and provide you with a new funding plan. And that's required to be done every year. Now, you don't have to use a reserve analyst for that service if you have an accounting firm or whatever, but the association is required to adopt a funding plan each and every year. So the visual inspection we talked about is once every 3 years. The review or the update only is annually. And of course, you have to provide and look for that funding plan each year as your, goal of looking. This is a form that you guys should love to death because you created it. Yes, this was created by the California Association of Realtors, and it is designed to inform consumers and protect real estate agents. And you can see it is very detailed. And so with this item here, a consumer knows exactly what they're doing. Number one, okay, what are my assessments? Oh, and by how much of that is going away to the reserve fund? Okay, terrific. Number 2, are there any special assessments that have already been approved? Let me know about that. Number 3, is our current situation going to be okay for the next 30 years? Well, if the answer is yes, then that would give a potential purchaser some ease. If the answer is no, like, okay, that's fine. That's good to know. But number 4, now tell us specifically in each and every year what years you're going to have a special assessment. So you've told us what you're putting away now. Now you have to tell us in each and every instance when you're going to have to collect more than that for the next 30 years. Very detailed. All the major components are put in there. So that's a statement that says everything's in there. If something's not in there, well, then you would probably go to the person who prepared that report to ask why something was omitted. Then they have some basic calculations because there's a number of ways. The calculation method that I explained to you earlier is part of it, but if they choose a different calculation method, then that's fine. This form was designed by you folks to make sure that whatever decision is made on behalf of the HOA, it gets disclosed to the member and particularly the prospective member, because this form here is required to be attached to each pro forma operating budget. And then they have what's called a funding plan. So the association is required a funding plan. As you can see, they're very detailed. So it talks, tell me what the regular assessment is going to be. Are there any special assessments that we're asking for in that particular year? Interest income, right? You have money now, you're going to make money on that money. Let's put that into the calculation. Component cost. Every year you buy stuff, right? So we'll put in some years you spend a lot of money, some years you less money, but we need to know that for our bookkeeping aspect. Excuse me, the net receipts are disbursements. So some years you bring in more than you spend, other years you bring in more than you spend. We just want to know. So you see some years they're in parentheses, others are not. So we want to know, of course, your beginning cash balance. That's an important number. And then, of course, your ending cash balance, which is nothing more than the components deducted from your beginning cash balance. The estimated liability, that's all of the accumulated depreciation. So all of the components, where they are at this particular point in time, that's what is the estimated liability or the accumulated depreciation, as they say in the civil code. And in this scenario here, you see it's currently $936,000, less the balance that they have, which is $169,000. So that means these fine folks are upside down, meaning negative equity of $766,110. Oh my God, what does that mean for me and my 58 units? Oh, I got that math for you. It's $13,208. So that's how much this association is, quote, underwater. All these numbers that you see here are required to be included in this information by law so that people can make an informed purchase decision. And these are required to go out for 30 years. So you can no longer have the I didn't know argument, right? You know, it was very specific on the information that they gave you. Here's the summary, also required. You see at the top, it's the basic information. So what year are we talking about? What inflation factor are we using against the current cost? The interest that we're going to earn on our money, of course, that beginning balance, which is an important number, and then a divisible number. How many units are going to start splitting all these monies? Then that next group down is just the reserve contribution. So just the money we're putting away for the future. So you see in this scenario here, line item F is, this is what the association is currently doing. They're telling us that they're putting $5,800 away, and it works out to a little over $100 per month per unit. Okay. The recommendation of the reserve analyst in this scenario is that they increase that to $83.30 or $143.63. Keep your calculators in your pockets. That's $42.77. That's how much we're telling them they need to increase their assessments to put towards the reserve fund. That is a percent increase of 42.4. We're going to talk about that in a second. Good news, no special assessment. So we're not recommending a special assessment. So while we're recommending an increase to your regular assessments, we're not recommending a special assessment. Line K is, well, we're going to ask for more future. So you see the next 2 years, another 42.4%. I've got another slide to show you in a second on that. Then this next group down is, okay, what's the overall? How does that impact the overall? So currently the association said, well, we're collecting $30,000 a month, $521.48. The reserve contribution total assessment percentage is currently 19.34. Now, the reason that that is important is, as you probably know, FHA requires that 10% of your operating income be given to reserves. So we want to put that number out there. So this particular association currently is putting 19.34. So they're, of course, covered that 10% minimum. Now, to effectuate the plan that of the recommendation to increase that $42.77, they're going to have to increase their assessments by 8.2%. And again, that's important because remember from Karen's discussion a moment ago, they only have a 20% limit. So if they want to go over 20%, they have to go to the membership. So we want to show where these percentages and how they fall in line. So in this scenario here, the good news is the board can effectuate this at their choice. It's not calling for a special assessment, certainly not a special assessment that would require a membership approval, and it's not recommending an assessment increase that is greater than 20%. So all of the issues here can be decided by the board of directors. And again, it's entirely their decision. They're not required to follow the recommendation of the reserve analyst, although they should probably have a pretty good reason why they're not. Then we look down a little bit further and we see this overage deficit. And again, this is in here because it was required by the civil code to let the people know that 766,110 divided by the number of units is 13,208. Now, the reason it is in there and the reason it's in there like that was it was put in there by the real estate lobby so that they can do their job. So if I recall how it worked, like I said, it's been a while since I was in the real estate industry, but if I recall, you put people in your car, you drive them around for 6 or 8 weeks, you show them 375 homes. They make an offer on 42 of them, only 2 of which get read, and you finally get 1 approved. That's rough numbers, right? So we've gone through all the process of showing the home, negotiating, and we've got an offer and approval, and bam, now we get hit with this giant package of disclosure information. So when I said I was willing to pay XYZ for that particular property because, hey, it's a great 3-bedroom, 2-bath in the best school district in the area, yeah, that's before I found out that they're upside down by $13,209 per unit. So that changes my perspective. And that allows the real estate professional to go in and do their job. So I can tell you that if you are in a buyer's market, and those exist, by the way, I'm old enough to remember when a buyer's market did exist. So there is such thing as a buyer's market. So in a buyer's market, let's say you've got a divorced couple, they got a lot of equity in the property, they're anxious to get out, you might get some movement on that $13,000. Yeah, it's possible. But if you're in a seller's market like you are today, or the seller is trying to get out of town before the bankruptcy court rolls over them, well, I doubt you're going to get any movement at all on that $13,000. Probably not going to happen in those circumstances. But what is important is that in all of those circumstances, that number is known and disclosed and it's through the process. So somebody can't say after the fact, after escrow is closed, oh, you didn't tell me that I was underwater by $13,000. So it's in there for a very specific reason for you to be able to do your function and for the disclosure for the prospective members. Then that next group down there, you see funds to cover the cost of components that need to be replaced within the next 5 years. That's there for the lending institutions because they like to, look at things quickly. So the summary, it says, okay, great. So they're going to have to spend $483,000 in the next 5 years. Okay, great. And then I go back up to line item D. How much money do I have now? Oh, wow. $169,898. Wow. And I'm only putting away the $5,000 a month. That's yeah. So real quick, I can tell that these folks are going to have to increase their assessments significantly in order to meet their obligations. So this is a loan profile that I would review in more detail after looking at that. And then you see this next group down is just simply giving you the percentages. So at the start of the year, it's 18%. If you follow the recommendations of the reserve analyst and increase your assessments, you're going to end the year at 23.9%. So again, all of this information is generally required in the civil code, and all the stuff that you see in 10-point bold type is specifically required to be in there in 10-point bold type. That's how specific they get. Despite our efforts, there are still a few folks that are not required to get reserve studies. We'll keep working on that one. But those that are not required to get reserve studies are if you don't have a common area, right? If there's no common area, then of course you don't have a reserve study because you don't have common components to maintain. So you'll still have an operating budget, right? You got your insurances and your other costs, but you won't need a reserve study because you don't have any common area components. Also, if you are a commercial or industrial zone, property. Those are known as common interest developments, obviously not HOAs because they're not a homeowners association. They're known as POAs, property owners associations. They have their own section of the civil code. I believe it starts at 6100, but they are excluded from the Davis-Stirling Act and thus don't have to have a reserve study. Also, there's a financial tool in there. So if equal to 1/2, if the major components are equal to or greater than 1/2 of the gross budget. So hypothetically, if you have a $100,000 budget, if all of your reserve components added up together are less than $50,000, you don't have to have a reserve study. It's considered insignificant. You can deal with it as it is. So very few associations qualify for this. So maybe a PUD that has public streets and maybe a pocket park, that might qualify for it. If you're a townhouse or a condominium that you're responsible for the structure and roofing, plumbing, or asphalt or anything like that, you wouldn't fall into that. But they do have this relief for those small HOAs or those that don't have the financial risk as others. Calculation methodology. This is outlined in the civil code. And so it's a very basic process. So you see at the top there, we've got a roof. Life expectancy is 15 years. Estimated remaining is 5. It costs $20,000 in today's dollars. The accumulated cost, the annual cost is $1,333. And that is nothing more than the $20,000 cost divided by the 15 years that it lasts. So on an annual basis, it cost us $1,333. So at this point in time, I've had 10 years of elapsed time on that. So I should have $13,333 in the bank in my reserve fund prepared for that roof, even though I'm not going to spend that money for 5 more years. The water heater, you see it's estimated to be 10 years, 5 remaining. Its cost is $1,000. So again, the 1,000 divided by the 10 would be the $100. It's 5 years old. So multiply the 5 by the 100 and you come up with $500. So those two items added up is $13,883. So at this particular point in time, if you have the $13,833, you are 100% fully funded. You don't need the $21,000 full replacement because you're not there yet. That's the full total. So in 5 years, you should have that amount. So the accumulated depreciation is nothing more than 100% of the accumulation at that point in time. Okay, well, who can perform them? Well, let's see. The community manager can. I don't know, Karen, if you want to do that, if that's something you feel like you want to involve in your service, if you're insured for it, but we certainly don't recommend it. The civil code doesn't prohibit a unit member from doing it. So they can. Now, what I will say is that you've got some issues there that you want to have dealt with. One is the competency, right? So if Harry in Unit 3B is competent, then yeah, sure, let him do your reserve study. If he's not competent, well, then you as a board have made a poor decision to allow somebody who is incapable of doing the job. The other aspect that you should look for, not only in your reserve practitioner, but in anybody else, is that they're properly insured, right? AJ talked about this a little bit. If somebody comes on site, if a contractor is on site and they don't have the proper insurances and they get injured or somebody on their crew gets injured, you by default become their employer. And it's a long process. We don't need to explain it, but that's what happens in the real world. So you want to make sure you have professional liability insurance. If they made a professional judgment call, oops, I forgot that this property had a roof. Oopsie doopsie, that may impact the financials. General liability, yeah, while I was out looking at the property, my ladder fell and broke a big plate glass window. I need something for that. And workers' compensation, as we talked about. So anybody who's going to come out to the property, you want to make sure they're privately covered. So we've got the site visit, which we do a physical analysis. And so after we've gone to the property, we got this list. So you can see here, that's the component inventory. They're generally done either systemically or geographically. So you see in this case, they're broken down systemically between the roof, structure, paint, etc. They have an ID number so you can identify when transferring monies. They have the approximate quantities. This will vary. Some are numbers, some are lineal foot, some are square yards, whatever the calculation methodology might be. We show you what the useful and remaining lives are there and what the current cost is in today's dollars. Again, those will be inflated, and we'll show that later. And then the annual depreciation. So this gives you the most basic down and dirty kind of information about what's going on with the property. That's the component inventory. Also, most particularly if it's had a site visit, we'll have a condition assessment section, and most of them will include a photo. So if you don't happen to know what a centrifugal pump is, well, they'll have a picture of that centrifugal pump so that you can see. They'll also have a description of what it does or its functionality and what condition it's in. So our financial analysis is, okay, what are we going to be bringing in and what are we going to be taking out for the next 30 years? And see, this is, and it's required in all reserve studies, this is a component replacement schedule, often called a liability schedule, but this identifies all those components. You see it mirrors that component inventory we looked at, and it shows you the years in which you anticipate that expense. So you see most of them are zeros, but then you'll see it show up. So you might be able to see that building signs down there. So it's $500 and then nothing the next year and then $520. So you see it's a short life cycle. These are signs that get replaced pretty frequently. So every other year you're putting in a batch of signs, and you see that cost is going from 520 to 540, 562 is nothing more than the inflation factor over time. So at the bottom of that, it will show you what you're expected to spend. And this is the importance for the planning purposes, because not only every HOA, not only every residence, every building has what we know in the industry as a wow year. Because you run along these routine expenditures and you say, hey, yeah, I spent this, I spent that. So we look at this here. So in this, the first year, we're going to spend $21,000. All right, next year, hey, good news. We're not spending anything. Oh, and then 123, that sounds like a lot. 198, wow, that's a lot. 140. So we're kind of used to spending around $100,000 a year. Well, let's look out a little bit at 2031. Look at that, $569,000. There's your wow year. You're spending, 4 or 5 times what you're normally. And so, yeah, this association we knew a minute ago, they had like $160,000 in the bank. So most years that's going to be okay. They'll be able to cover most things with that kind of a balance. They're not going to be able to cover that in 2031. I'm assuming if you looked up at the report, that's probably the roof coming in to do there, or asphalt, or another big component. So that's the importance of the reserve study, is to make you prepared for the wow year. Yeah, of course, you're always going to have a little bit of money in the bank and you should be able to deal with most of the expenses. It's the 5 or 6 really big ticket items in any reserve study that present the most risk. So now that we have an idea how much we're going to spend, we can create our funding plan, right? So we slide in our costs. So you see that component cost B? Well, that's nothing more than the bottom of the component inventory, the component replacement schedule. So all those years we put in our cost, and we know how much we started with a beginning balance. So that lets us know how much we're going to have to bring in, of course, 1, to cover our expenses, and 2, start saving up for future expenses, because you don't want to go to 0 every year. Karen talked a little bit about these funding limitations, but I bring it up to show that if you are underfunded in your reserves, you can really get it back pretty quickly. So in this hypothetical scenario, we've got operating expenses of $90, reserve contribution of $10, and our total assessment is $100. Okay, terrific. Now we know from Karen's program that you can increase that by 20%, right? So I can go in year 1, I go from $100 to $120. Wow. And then the next year I could do another 20% on that. So I go from 120 to 144. Well, the next year I could still do 20%. So I go from 144 to 172. And then the year after that, I go to 212. So in 4 years, I've doubled my assessments. So any idea that the board does not have authority or the capabilities to increase that? No, because assuming that your operating expenses are only going up inflationary 3, 4, 5, 6, 7% in a bad year, well, that 20%, you could be putting 15% or more of that additional revenue into your reserves to play catch up. So again, the association has the authority to do that. It's whether, of course, that's what they believe is the best decision and they want to make. Talking about the 5%, it's a relatively small number. So 5%. So in this scenario here, if it's $100, well, 5 by 12 is 60. So it's only $60 per year. So those are nominal amounts. So while some people may not like that, it's not going to be a tremendous issue. Doubling your assessments in 4 years, that's a tremendous issue. But it's important to increase your assessments because here's what happens. It never raises dues vistas, and they're out there because anybody who's been in property management for a long time has heard the phrase, when I was on the board, I never raised dues. I was on the board for 9 years, but never raised dues. They brag about that. And sometimes these people win elections because that's kind of popular that, hey, I'm going to keep the assessments the same. And so we've got a scenario here with never raises dues. So in year one, the total assessments were $100, and that's because the operating expenses totaled $90 and the reserve contribution recommendation was $10. So the total assessments were recommended to be $100 by their community manager, their CPA, and their reserve analyst. So they got professional advice to have $100 as their assessment broken down between the 90 and the 10. And then the next year goes by. And by the way, my first question for most of the people that brag, they went like 7 years without increasing assessments, is how they beat inflation for that long. Because, you know, other than I think 2009, which had some stagflation, inflation exists every year. So I'm curious how they beat that, but that I digress. So in year two, we've had inflation. And in this scenario here, now our costs are $103 because we've got $92.40 for our operating expenses and $10.60 for our reserve contribution. But remember, Mr. I didn't raise assessments, right? I never raised the dues. So the revenue that we have to work with is $100. So now I want you to sit back and think for yourselves about what your knowledge of an HOA is. So I want you to think, what happens to an HOA that stops paying its landscaper? And while you're thinking of that one, what happens to an HOA that stops paying its insurance premium? And then finally, in the same context, what happens to an HOA that stops paying its water bill? Well, as you might suspect, the same thing that happens at your house and every other place. Your landscaper stops showing up, they cancel your insurance, and they turn off your water. So as you can imagine, HOAs pay those bills. Yeah, they pay their landscaper because they don't want the place to look terrible. They pay their insurance premium because they're required by law to have the insurance and it's a risk issue. And they like water, so they continue to pay their utilities. So they will pay their operating expenses because they like those services or they're required by law. Now, because they only brought in the $100 because Mr. I never raised dues is on the board, they only have $8.60 left. So no, they don't have the $10 that was recommended or that they were reporting in last year. They certainly don't have the $10.60 that's recommended for this year. They have the $8.60. And as you can see in year three, it gets even worse because they're still left with that same $100. Their operating expenses, which they of course are going to pay, have increased to $94. And so now they're left with $5.60. And so you can see it doesn't take but a few years until one, your reserve fund is terribly underfunded, or two, you have to increase assessments just to keep up with operating. We have associations, sad as it is, that are putting $0 into the reserve fund because over time and not increasing assessments, now their operating expenses have absorbed all of the reserve contribution and now it just covers their expenses. So again, it doesn't take very long for you to get in a negative financial position by keeping your assessments the same year over year over year. People hate it when you do it, so do it every year. All right, so the association, as I mentioned, is not required to adopt the funding plan that is recommended by the practitioner. They can adopt anything that they want. However, they are required to give the funding plan they adopt to the board. So whatever choice they've made, they have to show that to the membership. And we've talked about earlier, it's very detailed information that goes out on a 30-year projection. And then back to our favorite form here. And I don't know how many of you know Gov Hutchinson or Ron Kingston or any of those fine gentlemen, but they do a terrific job for you. The next time you see them, go up and give them a great big hug. Ask first, but give them a great big hug because they've done it. I may have mentioned at the start, reserve analyst is a niche industry. There's only about 35 credentialed professionals in the state of California with my credential, the PRA or the RS. Despite that fact, we do have one of the most powerful lobbies in the state of California. You might have heard of them. They're called the California Association of Realtors. And they create laws that require people to use reserve studies. And this is one of them. And so we talked about this form before, that this form, when properly filled out, is one, great information for consumers to make an informed purchase decision. It is also a tremendous liability protector for a real estate professional because it is virtually impossible to sue a real estate professional for the financial condition of an HOA if this form exists. Why? Because you were told. The assessments, we told you how much they were. We told you how much was going into the reserve fund. We told you whether there were or weren't any special assessments approved. We told you whether there were or weren't special assessments anticipated. And we showed you the calculation method and where you would end up specifically over the next 5 years. And of course, the reserve study went out 30. So it's very difficult to sue a real estate professional over the financial condition of an HOA when this form exists. So I recommend that you have this, of course, with all transactions. Now, despite our lobbying efforts on behalf of the wonderful realtors and the reserve analysts, there are some associations that don't have reserve studies. Don't worry, the real estate lobby has taken care of that, as you all know, in the car contract. There's a little form there, a little section that says, oh, yeah, I know a reserve study is a really good document and all that, but they don't have one. This association doesn't have one. And as I mentioned earlier, this is a really great 3-bedroom, 2-bath in the best school district in the area. So I'm just going to buy blind. Yeah, I'm going to sign that waiver and recognize that I don't have this important financial information and I'm going to buy that property. Now, that will give you the same liability protection as this document here, right? Because if they have this document, they can't go after you because they were told. If they have that waiver, then they can't go after you because they were told, hey, you had an opportunity for this wonderful document. You said, yeah, I'm fine without it. So good news for you that this document and the waiver provide you liability protection. The difference between the waiver and this document is that the waiver gets you 0 referrals. Yeah, 0. I've been doing this for over 20 years. We do several hundred reserve studies a year. I do a lot of public speaking. I meet literally hundreds of these people every year because you can imagine when they're getting special assessed or their assessments are going up rather large, the great Karen Thompsons of the world and all that, they want to make sure that they're hearing it right from the people. So they invite me to the membership meeting and they say, we're all going to get special assessed and Scott is here to tell you why, and then they walk off stage. And I'm left there to explain to them reasonably why they're getting all these assessments. So I meet literally hundreds of people a year who are getting these special assessments. And Karen noted earlier that she called it a special assessment, which shows you, by the way, that the civil code is written by out-of-touch attorneys. As I mentioned, been doing this a long time. I've met a lot of people paying these assessments. None of them really thought it was all that special. It was kind of a surprise for some of them. So you want to call it a surprise assessment. I'm all down for that. But so when you don't have this document, and then they get that, they're going to find out. Sometimes it's months, sometimes it's years, but eventually they're going to find out. And I've seen the look on their faces, and you can just see the moment in their eyes when they realize what has happened, that they've bought a piece of real estate, that they had information that was available to them, and they just simply didn't have it. And their, I'll just say, pleasure with the real estate agent at that point plummets. So my recommendation to you is don't let them do that. As we've talked about, the association is required by law to have this document. So all you have to do is remind the association management, the association board, or the association legal counsel that you have a home for sale and that you may be negatively impacted financially by the lack of this particular document. Because if I was buying a home and they didn't have a reserve study, well, I'd be lopping off my offer, right? I'm saying, hey, I got to cover my risk. I know one property, it was $13,000 per unit underwater. So I've got to protect myself. So I'm going to do that. So now that you've informed corporate counsel that you have a member that has a financial loss because of the board's inability to follow the law, well, I think you're in a different situation. So my recommendation to the real estate lobby and the community is don't do it. Don't do it. Make them produce the documents they're required to have by law. Let your owners make an informed purchase decision so that after the transaction, whether they find out, you know, it's bad news, better to know the bad news going in than finding out after. So let's just get it all up front. So that is my recommendation for that. So following up on First discussion. Make an effort to ensure your clients have copies of all the important HOA documents, the CC&Rs, the policies, the budgets, all of that, as outlined in the document we gave you, the Davis-Sterling Act 5200. So if you want to remind people that you're working with on what documents are available through the civil code, there it is. Make an effort to ensure your clients understand the use restrictions and the personal items. So again, pet restrictions, parking, all that stuff. Make sure they've taken the time to read and understand that. And if they don't understand it, send them to cai.org and they can talk to a professional who will walk them through that. Also, you want to make sure that they have all the financial information, that reserve study. Don't let them get away with that, oh, I don't have that. Make sure all their financial information is up to date. That's required by law, as Karen spoke about. Same scenario. It's not your job as a real estate professional to go through those documents with them. Refer them to a professional who can help them out. And then last but not least, of course, AJ section. Let's make sure that they're talking to a licensed and experienced insurance agent so that they know what policies they need to protect their personal interests based on, of course, the HOA and its unique circumstances. So with that, we are done with the program. We're a little bit early and we are going to open it up to questions, comments, concerns, bitches, gripes, goals, dreams, aspirations.
There's a question in the Q&A, Scott, that I think would be a good one for you. David Coe is asking, what's the typical percent funding for a condo in Orange County? And does anyone have stats on this? I've heard some HOAs trying to put special assessments when it falls under 60%, et cetera. Not sure what the threshold is or rule of thumb, if any.
Okay, good question. Well, first, there is no empirical data. As I talked about at the start, the state doesn't keep any of that data. So there's nowhere that all the data would go. So there's no empirical data. Now, with that said, myself, other practitioners such as Karen, AJ, you know, we have a feel for it. I can tell you every time that I've surveyed our portfolio or spoken to other reserve professionals, the median and the average both come into the 30 percentile range, which I know is woefully depressing. So yes, most associations are going to find themselves in that 30 percentile range. To give you some risk perspective, generally speaking, if you are 75% or more funded, your risk for special assessment is almost non-existent, right? Because these are conservative by nature. So if you have 75% more of the funding you're required to have, the chances that something unexpected comes before it was anticipated, costs more than all of that, chances are you're going to be able to weather that storm without a special assessment because you're so well funded. Now we'll drop down to another category, 50%. You're still relatively protected against a special assessment because, again, these are conservative documents. But you might have to. And also, if you're at 50% funded, you've been kicking the can down the road, so you can anticipate your regular assessments are going to have to outpace inflation so that you can play catch up. Now we go down a tier to the 25%. If you're that 25 to 50%, there's a fairly high risk of special assessment. And of course, whether you have a special assessment or not, you can absolutely count that your regular assessments are going to have to far outpace inflation. And then we'll get down to that last group. If you're under 25% funded, there's more than likely a special assessment in your future. The amount and when, we'd have to look at the documents, but more than likely, if you're an association that's less than 25% funded, you can anticipate one or more special assessments in your future. And of course, you can anticipate that the regular assessments are going to have to far outpace those. So when it comes to what's a good percent funded, it depends on what your tolerance for risk is. I will tell you that, again, most of us in this profession, that when you fall below 50%, we will be more aggressive in our recommendations that, you know, you've kicked the can down the road long enough, it starts time to put something away. So that's the general rule. But quite frankly, we have associations that are more than 100% funded, which is an issue all unto itself. And we have associations that are 0.0 something percent funded. So they run in all gambits. But thank you for the question.
We have another one from Kevin Horn. Do banks
Okay.
review reserve studies when making credit decisions?
Yes, they do. They make them on both accounts. So we weren't talking about HOAs borrow money too. We didn't talk about that, but yeah, HOAs can borrow money. And if that's the case, then yes, absolutely. They get a fine tooth comb through the reserve study. But just the transactions of units, yes, the lenders are going to ask for a reserve study. You guys probably, and of course, Orange County isn't the bastion of FHA financing given the price of real estate, but you still use FHA financing. Of course, there are people out there that take, you know, home equity loans and all that. So FHA financing is still an important tool out there. You know that FHA has recently, I'll say, revised their guidelines because they realized that after Champlain Towers, it's really not a good idea to loan money on a really terrible property. So now there's a lot of issues as to who's going to sign the checkbox that says, yeah, this property is free of defects and has no risk. So yeah, those are coming into play. So FHA will absolutely look at it for a buyer, but quite frankly, now I don't know any private lender, even if they're not using FHA backing, that provides real estate loans for a unit inside an HOA without a reserve study. Generally speaking, 24 to 36 months is the longest that they'll have a reserve study as far as its time. So you're going to need a fairly current reserve study in almost any transaction. Okay, as we talked about, CAA.org, you can find us and other professionals that can answer all of your questions. We have a lot of education available for people that live and operate in HOAs. So if you're interested in that, by all means, go on, see our calendar. As I've talked about, a lot of the benefits that we have are free of charge. So if you want to go onto our membership directory and find the hundreds of practitioners that know how to operate with HOAs, that's free of charge. Most of our educational stuff is free of charge. So I invite you to go to the website for all of our wonderful resources. So with that, we're going to be back 2 more times this year. We do this program 3 times a year. So if you want to see it again, come back. If not, tell your friends about it so that they can see it. We'll be back in June and again in November. Keep an eye on your CAI material for notification. With that, thank you all very much for your participation. It's been a great opportunity. Good night.
Thank you.